American way, but also the Swiss. And it's that Swiss influence that makes Australia unique with respect to the law making and, most importantly, where the authority lies. Okay, in other countries, one of their biggest problems is this horrible thing called parliamentary sovereignty. Now and this is why it's important that we understand the debates that led up to the Constitution. In those debates in 1891, they established and re-established in 1898, 1897, that Parliament in this country, including state and federal parliaments, cannot ever claim sovereignty in any way, shape or form. So Australia was an experiment. Okay. And that experiment was to establish the people's authority over and above any government.
So Shrout is actually, doing these presentations and charging fairly exorbitant fees for the DVD on the site. He even said he's come over in New Zealand giving these presentations.
Yep.
And he's basically saying his methods work worldwide because the law that's applied mostly in courts is corporate law.
In one sense he's right, but again there is our core procedures here have established well and truly leading up to about 1950 the Constitution as it was drafted, the difference that was with respect to any other country.
So you're saying that because, as you just mentioned, because Australia is special because we were kind of an experiment,
yep.
We actually, our Constitution, it's actually even more powerful than the kind of...
It's the most powerful in the world.
Wow.
And this is why they've kept it from you.
Wow.
Okay, this is why the emphasis has been so much on the football, meat pies and Holden cast. We've really got to break away from that spell that we're under as a population and seriously take up our role as sovereigns, because it has been wanting for 100 years plus now, and they are pretty much to the point where they're just about to boot it straight out the door at the drop of a hat. Any excuse given. We really need to understand what it is that's in that document and exercise that document and what it says against those who are bound by it. Okay, and one of the biggest problems we have, and I'll touch on this after the break, is the influence of foreign powers in this country. So we'll have a break for about...
You made the statement before that the magistrate or the judge said this is a state court.
Yeah.
Right? If this is a state court, then why do we have to stand up when the judge comes into the court? The reason we stand is because theoretically the Queen is the representative of the court, and I don't mind standing up as a subject of the Queen to her representative. But he claims that it's a court of the state, and that situation no longer exists. So why should we stand?
It's your prerogative, and this is an exercise of your sovereignty. When you are confronted with that, and the mistake I made in that particular case was I established that at the end of the case. You see, my history has been one of usually, and 99 times out of 10, I will find something new out the night before the court case. So all I want to do, I just want to get in there and tell them and put them on the spot, and of course, all of these principles sort of go out the door. But I'm kidding me. They respect me for that in that sense, and I suppose in one sense, I am on the bullseye of their dartboards in all of their lunchrooms, and they respect me in that sense, but purely because I'm promoting this to the general public. I'm not hiding away in a hole going, wow, I've got immunity. No, I want everyone to find this out. And this is the key to the door. This is the one thing they're scared of. They're scared of you waking up. Our job is to wake up. It's not hard. It's a lot of fun, actually.
they challenged the judge about that standing up, but they said no one stands up when the judge comes in. The judge came in, and he didn't say anything, and he went on with it. And then later on he said, oh, why didn't you stand when I come in? He said, we don't have to stand. That's only just a formality, you know.
Yeah.
It's not.
It's an old maxim that's been around because of an allegiance to the sovereign. But the sovereignty in that room really is the jury. They're the real judges. They're the ones that we stand up to and that we acknowledge because they're our people.
Steve's got to have a quick word before we break.
Okay.
Hand over to Steve.
Okay, about a month ago, along with some of the people in this room, I attended an evening with Mark Murtry, who is, I guess, a leader in the tribal communities as far as sovereignty is concerned. Subsequent to that, I spoke with him to see his interest of having a 2-day seminar in Melbourne, and he was quite receptive. What I'm proposing to do is there's a red book by the door there with a red pen. If you're interested in attending a 2-day workshop with Mark, not sure of dates yet. Cover fee would be about $50 to cover his expenses to fly down, accommodate, and also arrange a venue. So if you're interested in that sort of seminar, just leave your details in the book, and I'll keep in touch with you via email.
Steve, what's he do?
Sorry.
What does he do?
He's been studying law for about 20 years. If you look up YouTube, he's all over it. He's basically with he and probably Michael Anderson are two leaders in terms of research of law as far as the Aboriginal and tribal people in Australia and their sovereignty. And with the research that he's performed, basically has evidence that shows that the Aboriginal and tribal people never ceded their sovereignty and are not subject to Commonwealth or the Crown's laws, and that they have been, or he has been, involved in basically uniting the tribes and also, I guess, instigating a process of private treaty, such that his approach is that to starve the beast, you remove what they feed off, and what they need is the people. And so through the concept of the private treaties, which he's endorsing and has helped people with, is basically removing people from the jurisdiction of the courts. But as I said, as I think the gentleman said, have a look at YouTube. There's a whole lot of videos. You'll get a general idea about what he's about, because I can't explain it in 2 minutes.
No. Very clever man. Mark MC.
Okay, folks, thanks very much. We'll break now and we'll come back later. 20 minutes.
A couple of concerns that come to me during the break. One of those is when referring to the Commonwealth Constitution, the proper term is an act to constitute the Commonwealth of Australia, 63 and 64, Chapter 12, Queen Victoria. An act to constitute the Commonwealth of Australia, 63 and 64, Chapter 12, Queen Victoria. That's the proper terminology with respect to the Commonwealth Constitution. And we only, as people, have power to alter Clause 9, which is the 128 sections of that Constitution. And Section 128 is that power of referendum. It's also mentioned in Section 123. So I'll just clarify that. Now, Section, I'll wait till Colin gets back, but there are only, under the Commonwealth of Australia Constitution, there are only two arms of government which are recognised. government and one is local government. No, you've got to listen very carefully. Local government. Now, when I say the words local government, I'm referring to the Quick and Garran. Quick and Garran and the many people who debated the creation of our constitution, when they referred to the states, they referred to the states as local government. Okay. Because we all live in the states. But first and foremost, as of federation, we are in the Commonwealth. Okay. Now the Commonwealth is a political union, and that was established along with England and all the states of the Commonwealth. Okay. So it's important to grasp that. Now, the people that have been our elected representatives in the last 100 years, for one reason or another, have been trying to undo that Commonwealth Australia Constitution and undo the people's power, ultimately. And in their infinite wisdom, they have been drafting questions which really are quite embarrassing to those like myself and others who have studied the Constitution. In 1988, they really made a major move. They asked a fairly straightforward question, and that was, do you recognise local government? And Australia said no. 68.7% said no. So in pure law, the states were eliminated in 1988.
Oh.
In pure law. Okay.
That's a nice one.
Just the state governments or the board?
The states. Local, do you recognise local government?
No, sorry. The other question was for the establishment and continuance of the system of local government within the state and to enact bylaws by the state.
Yeah, it does.
And we said no.
Yes, there's no.
We said no.
And that they'd be able to make local laws.
Yeah.
Yeah, isn't it our understanding is parallel others? So our understanding of local would be that it's it would be local municipal.
Our understanding is when we read the law, and as sovereigns, we do not just take hearsay as what law is. We look at law and we look at the meaning of the law. Like I said earlier at the beginning of this meeting, we look at each word that appears in each section. We understand it in that context. We apply that right throughout. This is why we have been doing the study that we have been doing.
We hear it all over the general population, yet I'm sure most of the people in this group would have thought that local meant literally municipal.
Yeah, absolutely, because we've been brainwashed for quite some time. But the federal government has been trying to establish the local councils, the local shires, in the constitution of the Commonwealth for quite some time, predominantly since Whitlam's time. And the first question that was put to the Australian people back in 1973, I think it was, in a referendum, was
The Brown. That's the local government.
yeah, that's what they, as a result of the 88. But in 1973, Whitlam put to us, will you allow us to fund local government out of consolidated revenue? And Australia said no. So they got their first knock back in 1973. So they thought they'd try again in 1988, only this time, rather than ask for funding, which was a really sneaky way of bringing it in, they just asked us straight out, do you recognise it? And we said no.
That's the writ that's up in Brown. It's there now.
What power does that referendum decision have in federal law?